Everybody, it's Dave Stous. I'm a partner at Husch Blackwell, a member of Husch Blackwell's Privacy and Cybersecurity practice group here in the Denver office. I want to thank you for joining us on our webinar today. As usual, we have far more content than the 1 hour allotment allows for us. But I want to try to, at least in the intro here, just kind of walk you through a bunch of the housekeeping measures. First off, those are your speakers here today. The QR codes will take you to our LinkedIn profiles. If you've done a webinar before, we always say, hey, if you're interested in this topic, you might want to follow us or friend us on LinkedIn. We tend to push out a lot of content in between webinars on Byteback and also on LinkedIn. As far as housekeeping measures go, if you have questions, feel free to ask them. Obviously, we're talking a lot, and a lot of these things are pretty nuanced, these questions. So we'll do our best to answer them along the way, but chances are if we don't get to them, we might try to circle up. You can always send us an email too, and we'll try to answer your question. We offer CLE credits. We like to think you're here for us, but you're probably here for the CLE credits. So we offer CLE credits. I think there's a button that you just press to get access to those CLE credits. But if you have any questions about that one, I typically get like an email or two after each webinar asking about CLEs. Feel free to send them. We want to make sure you guys get hooked up with those CLE credits. If you've attended one of our previous webinars, you know we like to start with a roadmap. This gives you guys an understanding of where we're going. Hopefully heads off some of those questions along the way. So here we got it, 8 topics today. A lot to get through, like I said, in an hour. What I'll kind of give you the high level here is, 2 through 6 here is really the substance of the statute. And we're simple people, I always say. We just went through the statute. And then we're just going to kind of lay it out for you in numbers 2 through 6 here. 1, 7, and 8 are context parts of this. So we're going to give you some background on the statute and how it came to be. And then like some what to do's now, some thought process about what you can be up to now. And then, frankly, what's coming down the pike. We've still got a couple, well, California in particular is still out there with some bills. Okay. So typically get asked question of like, hey, do you have a reference to the statute itself? You can use the QR code to get after it to SB 205. And also we've done a blog post on this as well. So just some more information for you guys to use. Okay, so with all of that background in mind, I want to kind of pivot and talk to you all about where this law came from. As I was trying to sit down, I talked with Shelby and Eric and Owen about this, right? I'm kind of cognizant of the fact that we've been doing webinars on Husch's platform for about 5 years now, right? And, for those 5 years, we've been talking to you all about privacy. We've been starting with California, and even most recently, we did our update one just a few months ago on all the different state privacy laws that are out there. This is a new topic, and I want to be sensitive to the fact that it's a new topic for a lot of people. I mean, it's a topic for everybody. It's a first-in-nation law. There's overlap with privacy law, no doubt about it. There's a reason why a bunch of privacy lawyers are talking to you about this topic. But I think some context here is really going to be important for everybody to kind of level set about what's going on here and what's the goals and the purposes of this law. So with that, I want to start here, right? And where here is this multi-state work group. For those of you who tracked it, you'll know that over the summer, Connecticut Senator Maroney organized this multi-state work group, right? And conceptually, what the idea was that Maroney had was, we've done privacy. We have a framework in place for privacy with the Washington Privacy Act framework that's been put in place in Connecticut and Colorado and all these other states that I don't have to repeat to you guys. The federal government has yet again not put forth a bill that's passed on AI, so the states are going to be looking at this issue, but they want to do it in an organized fashion that is not happenstance, right? Sort of learning from the mistakes of privacy where every state was doing something different. So this multi-state work group got put together. It was facilitated by Future Privacy Forum. It had lawmakers, bipartisan group of lawmakers from nearly 30 states. It met 7 times over the summer and the fall. And it heard from experts from across multiple fields and geographies. There was EU AI Act experts on there. There was experts from civil society, and there's experts from consumer groups. There was experts from tech companies as well. And then a second work group, Senator Maroney also had a second work group in Connecticut that was also looking at like a Connecticut-specific work group. Bills started, a draft of what became SB 2 in Connecticut started to circulate over the fall and then to the winter. And again, the purpose of this was sort of to have this sort of framework, these building blocks that could become essentially a Washington Privacy Act equivalent for AI legislation at the state level. Okay, so the question I think we get asked a lot in this one is, what's the point of this, right? What's the point of this legislation? And this is kind of, I think, the best way I can describe it. There was a lot that happened in this work group, and I should have mentioned too that we participated in the work group among a bunch of other organizations as well. But like these themes that came out from the work group were, one was this algorithmic discrimination, which is what we're talking about here today. We saw a bill get run last year in California, Bauer Cahan's bill, that did not pass. It's back this year. It's still pending. So this concept of like algorithmic discrimination was really prevalent during the work group meetings. And this was kind of like the best example of what I could find that really just kind of identified the issue in a really succinct way. And this is from FTC Commissioner Rebecca Slaughter. Her article was in the Yale Journal of Law and Technology a few years ago. And basically the idea being is that, algorithms are in consequential areas, high-risk areas. They're leading to, or believed to be leading to, bias and discriminatory results. So that is the issue at its core that policymakers were looking to address through this legislation. And you see this not only in California, but you've seen the bill run in Washington, D.C., the Stop Algorithmic Discriminations Act, for a number of years. So this has kind of been percolating. Now, there's this balancing act, right? And I think if you're part of this work group, you heard a lot of these themes, right? You heard, on the left side, you heard things like regulating in a complex and emerging area is going to hurt business. You heard things like regulation is going to hurt innovation. And you also heard, a very popular refrain from what we've dealt with in privacy law for the past few years, which is state laws, this patchwork is going to hurt businesses. We should have a federal law, not a state law. On the other side, what we heard in the work group was, hey, listen, we fell behind in privacy. We can't fall behind in AI, right? We waited for a number of years. Now we're trying to put the toothpaste back in the tube, so to speak. And that guardrails can provide for responsible innovation. So, would we try to go regulate after the fact and try to add, what we're doing in privacy, which is putting that toothpaste back in the tube? And if there's things that can be done through the law that would protect businesses, such as through the rebuttable presumption, the affirmative defense and no prior right of action, and we can also limit the scope to algorithmic discrimination. Now, what I'll suggest to you is, as you read this, depending upon your point of view, you may agree with the left side and may agree with the right side. I think where I kind of fall down is I think every single bullet point is accurate on this one. I think all of these things are true, which is what makes this such a complex area. So with that in mind, and before I turn it over to Shelby to go through definitions in 2 slides, she put me on the clock. Shelby put me on the clock. I'm trying very hard to stick by the number of hours because we have a bet on how long it would take me to get through the introductory phrase section. So the way I like to explain this one, right, is the concept was to come up with a basic framework, right? And so and this way I like to explain this. If you put 100 people in the room, right, and you said, hey, if you create a law around algorithmic discrimination, 100 people in the room would probably come up with boxes that look a lot like this, right? There would be general agreement on things like, hey, let's responsibly deploy AI. Let's do things like impact assessments and risk programs, those types of things, duty of care, right? Those types of things would be like, yeah, let's have responsible deployment. Let's provide some disclosures. Let's review it as needed. Let's have consumer rights associated with it. Probably the last box there, notifying AG's offices and relevant parties. That's probably a little bit controversial. But like for the most part, I think 100 people would agree this is the structure of what the law should look like, right? Now, where we would disagree certainly would be once we get into the specifics of what's going on here. But this is the basic regulatory framework that this SB 2 in Connecticut and SB 205 in Colorado tried to build out. Notwithstanding the fact that the specifics of the laws are obviously what we're going to spend the balance of the hour on here today, but those are really where like the rubber meets the road, so to speak, and these issues need to get fleshed out. And there's a lot of give and take. So I'll give you this one, and then I'll turn it over to Shelby, and she can start digging into the statute with the definitions. Governor Polis signs it in May of this year, just a couple weeks ago. There is a task force. There's a separate bill, 1468, which is the task force bill. It has been passed. It has not yet been signed by the governor. It will be signed by the governor. That is going to create a task force that needs to be created by August 1st of this year, and it has to report to the legislature February 1st of next year, right? The concept of this, and this is just really, I think, fundamentally important to understand here. The concept is that this law is not going to go into effect until February 1st of 2026, right? There is a legislative session in between the law passing and the law going into effect. And actually, there's even the tail end of, the opportunity to amend it a second time if need be to that next legislative session. So there's a year, and that year is intentional. The year is intended to have this work group look at issues and continue to flesh things out if need be, right? There's also rulemaking. There's AG rulemaking. Eric's going to talk about that at the end. But AG rulemaking is also going to happen, permissive rulemaking, somewhere along the lines here, right? So understand that while we present to you the Colorado AI Act in its form today, it is possible. Nobody can predict the future, but it is possible that it could change moving forward before it finally goes into effect a year, 8 months, and change from today. Okay, with that, I'm going to hand it over to Shelby, who's going to dig into the scope and relevant definitions.
Thanks, Dave. Great to be back with the team on another webinar. Like Dave said, I'm going to start with the scope and relevant definitions of Colorado's AI law. Since this law is focused on high-risk AI systems, what better place to start here? So we have broken this definition down into 3 main parts. Under Colorado's law, a high-risk AI system is an artificial intelligence system that is deployed and either makes a consequential decision or is a substantial factor in making a consequential decision. And so now I'm going to take the time to kind of walk through each part of what this definition means. Okay, so the first part of the definition is, what is an AI system? Colorado's law actually uses the same definition as the OECD, which is the Organization for Economic Cooperation and Development. So you can see Colorado focusing on consistency with its definition here. An AI system is any machine-based system that for any explicit or implicit objective infers from the inputs the system receives how to generate outputs, which includes content, decisions, predictions, or recommendations that can influence physical or virtual environments. So, that's a pretty basic definition we have here, but the nitty-gritty is the next part of this definition. What does it mean to be deployed? Under this law, to deploy means to use a high-risk artificial intelligence system. It's important to note that with this definition, it's targeting systems that are actually being used with consumers, with customers, or with products or services, not systems that are being used, kind of behind closed doors just for testing purposes. So they do need to be used. And then the third part of the definition of a high-risk AI system is the consequential decision aspect, which is where this idea of high risk comes in. This law is not targeting Gen AI, but AI that has a specific type of impact. So the law defines a consequential decision as a decision that has a material, legal, or similarly significant effect on the provision or denial to any consumer, changes the cost of or the terms of something for the consumer with the list presented here. So, we have education, employment, financial or lending, government services, healthcare, housing, insurance, and legal services. So, this is what we're looking at when we say a consequential decision. Does it have an impact on a decision that's being made with that consumer along the lines of this list? One important note that I do want to make is that it has to be a consequential decision involving a consumer. And so if you're familiar with privacy laws, you know that the definition of consumer can vary under privacy laws. Under this AI law, the consumer is defined as a Colorado resident. And so this is going to apply more broadly. Unlike the Colorado Privacy Act, this definition does include employees. So companies need to consider this, what AI systems they're using behind closed doors, as well as what they're using with consumers. So that's important to note. And then if you kind of remember that 3-part definition of a high-risk AI system, it comes down to whether the system makes a consequential decision or whether it is a substantial factor in making a consequential decision. So let's take a look at what is considered a substantial factor. Under this law, a substantial factor is one that assists in making a consequential decision, is capable of alerting the outcome of a consequential decision, and is generated by an AI system. So it includes any use of an AI system to, again, generate any content, decision, prediction, or recommendation that is used as a basis to make a consequential decision concerning a consumer. I think of a substantial factor as a pipeline decision. So when you have a pipeline decision, these are decisions that are made along the way to making the final decision. So if the AI system makes a decision that then leads to a final consequential system, then it's going to be captured by this law as well. So that's important to consider. So what many companies want to take a look at are there any exclusions to what is considered a high-risk AI system here? And so I'm going to touch on a number of them. The first is that a high-risk AI system does not include an AI system intended to perform a narrow procedural task or is intended to detect decision-making patterns or deviations from prior decision-making and is not intended to replace or influence a previously completed human assessment without sufficient human review. So this will not be considered a high-risk AI system. In addition, the term also excludes different types of activities, such as anti-fraud technology that does not use facial recognition technology, so that's an important distinction, anti-malware, cybersecurity, data storage, networking, spell checking, as long as they are not being used to make a consequential decision or are not a substantial factor in making a consequential decision. So those are the big exclusions we have for what is considered a high-risk AI system. So that's the first part where we covered scope and definitions, and I'm going to hand it over to Owen to talk about developers.
Thanks, Shelby, and thanks to everybody for joining today. So first, we're going to go talk a little bit more about definitions. So generally, the Colorado AI Act sort of takes a bifurcated approach to imposing obligations on stakeholders, developing and deploying AI. And so they divide the obligations between those who develop AI systems and deployers of high-risk AI systems. So for the definition of developer, we have a person or entity doing business in Colorado that develops or intentionally and substantially modifies an AI system. Intentional and substantial modification is defined as a deliberate change made to the system that results in new, reasonably foreseeable risks of algorithmic discrimination. Now, note there is a small exception to this that generally applies to AI systems that continuously learn and change based on that continuous learning, and also if it's a built-in change kind of predetermined by the deployer or third-party contracted by the deployer. Deployer, on the other hand, is a person or entity doing business in Colorado that simply uses high-risk AI system. Excuse me. You'll notice one difference in these definitions is that developer applies to any AI system, while deployer applies only to a high-risk AI system. So be aware of that in cases where you might still classify as a developer, even though, excuse me, you are not developing what's considered a high-risk AI system. So when it comes to developer obligations, there's about 4 categories of obligations that we've put together here, and I'll go through them clockwise, starting with the duty of care. Now, this is something that you will see similarly applies to deployers. So the general standard is that a developer of a high-risk AI system must use reasonable care to protect consumers from algorithmic discrimination. but note that it's discrimination arising from the intended and contracted uses of the high-risk AI system. So from a conceptual standpoint, this makes sense. Most developers, with respect to the AI systems that they build, they're not putting them in the wild. They're not going directly to consumers. So that phrase, intended and contracted uses, is really important. And I think that it really puts an emphasis on whether it's a licensing agreement between a deployer and a developer of an AI tool. It's just going to be very important for developers specifically to specify what are the intended uses of the system, and what's the system contracted to provide to a deployer. Similar, you'll see to a deployer's responsibility, there is a rebuttable presumption in the law that's provided to developers. Essentially, if you follow the law's other requirements, then you are assumed, or there's a presumption that you have satisfied the reasonable care standard. Okay, so moving to the meaning of algorithmic discrimination. Essentially, it's just any result from an AI system that disproportionately impacts a person or a group that's part of a protected class under Colorado and federal law, like Title VII. Note that there are some exclusions to this that we've listed here. The definition of algorithmic discrimination does not apply when the AI system being used, the sole purpose of it is for self-testing or to promote diversity, which I think will be important, especially in the employment context to keep in mind. And then also this definition, there's an exception for private clubs who simply are exempt from most anti-discrimination civil rights laws. All right, then moving to kind of the next category of obligations, there's a general disclosure requirement. And what you'll see with developers is that kind of the framework behind this is that developers are required to provide most of their disclosures and information regarding the system to deployers that use that system. You'll see with deployers, it kind of goes back to Dave and Shelby's earlier point that you kind of flow down the path to consumer, and that the deployer's obligations are more to the public and to the consumers who use the AI systems. So to begin, the first kind of set of disclosures is a general statement describing reasonably and foreseeable uses and known harmful or inappropriate uses of the system. Again, this is going to the deployer. Next, there is as a developer, you have to provide documentation that discloses the summaries of data used to train the system, known or reasonably foreseeable limits of the system, purposes, intended benefits and uses. And then there's generally like a catch-all for any information necessary for a deployer to comply with its obligations. And one thing to note, the information that a developer provides to a deployer can be, to the extent feasible, that's the phrase used in the law. You have to make the information available through artifacts such as model cards, data set cards, or other impact assessments. Note too that the law uses that term "make available." So there's it's purposefully broad, and we could see through rulemaking more specifics detailed around that. Continuing with the developers' disclosure obligations to deployers, you also have to provide documentation that describes how the system was evaluated for performance and to mitigate algorithmic discrimination. You have to provide data governance measures. Those are really used to cover training data sets and the measures used to examine like the suitability of the data sources being used. You have to describe the intended outputs of the system and measures taken to mitigate risks of algorithmic discrimination. And again, there's this focus on how the system should and should not be used and how it can be monitored by deployers to avoid algorithmic discrimination. Additional documentation. This is sort of another catch-all where you have to provide any additional, as a developer, you have to provide any additional documentation that's reasonably necessary to assist the deployer in understanding the outputs and to monitor performance of the system. Again, this kind of goes back to the general framework of deployers are putting the system out into the wild, but they're going to rely on the developers of the AI system to tell them how it should be used, what its intended purpose is, what are the risks. So there's sort of that flow down effect of kind of reliability and trustworthiness built in. Next, the next category for developer obligations is public disclosures. So while most of the disclosure obligations for developers is to deployers, there are also there are two sets of public disclosures required. So first, you have to, as a developer, you have to make public basically a summary description of the types of high-risk AI systems you've deployed or intentionally and substantially modified. And then you also have to provide a description of how you are managing known or reasonably foreseeable risks of algorithmic discrimination. And these need to be made available on the developer's website or a public use case inventory. Also worth noting is that you as a developer, you have to update these disclosures as necessary. This is the terminology used in the law, as necessary so that it remains accurate. But then you also have to update it no later than 90 days after you observe or believe that there's any new, you have to update no later than 90 days after you've intentionally and substantially modified the system. One caveat to note also with the public disclosures, there is a specific exemption in the bill around disclosing trade secrets or any information that's protected by another law. So that's important to keep in mind as a developer when you're going through these, when you're trying to satisfy these disclosure requirements. The next kind of obligation category for developers, similar to something you'll see for deployers, is that you have to notify parties, specific parties, when you notice any algorithmic discrimination. So again, you see this 90-day kind of time limit. You have to notify the Attorney General, and then you also have to notify any deployers or other developers that are deploying your system. Again, this disclosure is for any known or reasonably foreseeable risks of algorithmic discrimination. It is really a mouthful. So it's not, it's any time you sense a risk that you either notice it yourself through testing, or you get a credible report from a deployer or some other party that this specific risk has arisen. All right, now we'll move to deployer obligations. And as you can see, on balance, the deployers have more obligations than developers. I think that's a fair statement, as this beautiful graphic shows. Again, the thinking behind that is the deployer is actually applying or giving the consumers are interacting with the AI system that deployers provide. Deployers are putting these systems out into the wild. So first, again, like I had mentioned, there's a similar duty of care that deployers have to use reasonable care to protect consumers from algorithmic discrimination. Note that there is not the language in this particular standard around intended and contracted uses. But again, if a deployer follows all the other requirements in the law, there is this rebuttable presumption that they have followed and satisfied their standard. All right, with that, I'm going to pass it on to Eric to continue the deployer obligations.
Thanks, Owen. Hi, everybody. I'm going to pick up and build on what Owen just walked you through. If we think about the beautiful graphic that he just mentioned, and I'm going to take it on the right-hand side of that graphic, we're going to look at the obligations that are exclusively for deployers. So in this case, the first one is going to be an obligation when a deployer is utilizing a high-risk system to put in place a risk management policy and program. And what the slide shows you here are basically in the first block, who needs to be addressed and discussed in the policy and what does it need to be accounted for. So the law is looking to have an organization identify the people or the belly buttons that would be accountable for developing the principles and putting the processes in place, and then coming up with the ways to mitigate known or reasonably foreseeable risks of the algorithmic discrimination that Owen mentioned previously. The next obligation when it comes to this policy, and this is where you're going to hear that theme that Dave spoke about at the beginning with the context of continuing to come back and make sure that your AI model, the system and the tools are working as intended and producing outcomes that you expected and that are not causing unfair or disparate treatment or outcomes for people. So there's going to be an obligation to review and update your policy. And this isn't sort of a do it once and put it on the shelf. You really need to be thinking about systematic and regular updates. And I'll kind of tie that in with the next slide on perhaps a strategy and how you can think about this. The last question is going to be what's reasonable to go into the policy. And here the law starts to come into what we think about as some of the proportionality elements or obligations, not only with existing frameworks and standards that are out there, such as the NIST AI risk management framework or other frameworks that the Attorney General's office may identify as being acceptable, but also what's the size and complexity of the organization? And then what's the nature and the scope of the data that it's getting and how sensitive is it? For those of you coming out of the privacy community, if you're familiar with some of the state comprehensive privacy laws, we do talk about the size of the organization and the sensitivity of the data that they're processing as far as being tethered and linked to the obligations that they have. You can think that the concept is somewhat similar here as we look at the reasonableness for the policy. So again, the risk management policy needs to be prepared and developed put in place by the deployer. So now I want to contrast that with impact assessments. This again is an obligation that deployers must have an impact assessment. There's one important caveat though on, in a sense, who writes and completes the impact assessment. The law gives some flexibility for a deployer to contract with a third party to perform the impact assessment. If you are familiar with the government contracting industry or other industries and micro ecosystems of consultants and experts that can help companies participate with the GSA service schedule or with the Department of Defense cybersecurity programs, this may be one of those areas where we see a company that is not a small business exempt entity that Dave's going to talk about in a little bit, but rather a company that's 50 or more people, but isn't mature enough or robust enough to be tackling this topic on their own. They simply don't have the expertise. The provision of using a third party contracted to perform the impact assessment is to get a quality assessment in place for the tool when it's going to be put to use, but not to make it an insurmountable task for the organization. So that covers the who. When do you need to do an impact assessment? It needs to be done annually, and then within 90 days of any intentional or substantial modification to a high-risk system. So Owen talked about that definition of substantial modifications previously. This is not to include sort of incremental learning as your tool develops and matures, but it's that aspect of if you are changing what it was intended to do, then it's time to do another impact assessment. So if you think about this, at least once a year, and with any change, you need to be doing an impact assessment. I recommend, or perhaps we recommend, we can see if we have debate at the end, we can see if everybody thinks I'm out in left field on this. I would be thinking about my risk management policy updates that are required on a systematic basis to be done each time that I'm looking at my impact assessment and revisions there. And then what does the impact assessment need to do? It's these bullets that are up here on the slide. So there are 7 topics. In my mind, these are very similar. If you're familiar with the concepts of privacy by design or secure by design that are used for the data privacy world or the information security world, similar concepts here that are built into the precepts that either NIST looks at or the EU Commission looks at when we talk about trustworthy AI. Other obligation for the deployer is to have an annual review of how the model or the system is working. This is a really important topic, and Dave talked about it at the beginning as well before I give the microphone back to him. We want to make sure that these tools are behaving and performing in the way that they were intended when we buy them. If the models start to drift and you see outcomes that you weren't expecting, then by doing these annual reviews, it's in the organization's interest and it's to their benefit to be able to control and correct those deviations from what we expected. Folks here on the audience may be familiar with the use case of a large shipping company that developed an AI tool to hire leaders in its technology department. The engineers designed it to be gender blind and race blind. But the outcomes that they started seeing as the tool was going through resume scanning was that it was hiring and recommending white men to handle all the leadership jobs. And what was the reason for that? Well, unfortunately, in the 90s and the early 2000s, the industry was dominated by white men. So the model had started to learn, these are the people that get the jobs in the past. This must be the type of resume that I need to recommend and advance forward for consideration. So despite the best of intentions, we have a disparate, undesired outcome that happens. By monitoring the tools, you see those things start to develop and you can course correct. So Dave, with that, I'm going to pass it back to you.
Thanks, Eric. So let's move on, chat about consumer disclosures. Owen showed you that they keep on saying it's a beautiful diagram. I guess the things that come up with on Saturday mornings when you're working on slide decks. So this is, if you're kind of going around that wheel, this is the next one, consumer disclosures here. And yeah, I mean, let's just sit back, right, and kind of think about what the concept of this one is. Right, you've deployed a high-risk AI system. What should you do? You should, under law, you should tell consumers they're dealing with a high-risk AI system. And so you've got this notice aspect, and then you've got the statement aspect as well. If you go through the statute, it's just one after the other in the paragraphs here. The statement, I mean, it says exactly that, right? Provide the statement disclosing the purpose of the system, the nature of the decision, contact information, plain language, et cetera, et cetera. I think the next piece here, the opt-out of profiling, is really kind of the interesting piece here, right? So if we've referenced privacy statutes a number of times, but specifically referencing the Colorado Privacy Act here. If you're familiar with privacy law, Colorado's Colorado Privacy Act has the right to opt out of profiling of certain types of decisions, right? Automated decisions, which is very similar in concept to what we're talking about here. So conceptually, what the way this was designed is, it says if you're subject to that, if you have, you're subject to the Colorado Privacy Act and you have to provide the right to opt out of profiling, then you would in fact provide. What I'll suggest to you, though, is the way that the opt-out of profiling right has kind of really played out as we've seen these privacy laws go into effect. I don't think it's played out the way people thought it would, to be honest. And I think really part of the reason for that is a lot of the decisions that are talked about in profiling, which are very much the same as what we talk about with high-risk consequential decisions, which Shelby referred to earlier. These are things like, education, financial lending, healthcare, those types of things, right? But if you look at the exemptions in these privacy laws, they exempt things like, financial institutions. So Colorado Privacy Act exempts the Graham-Leach Bodily Act financial institutions, right? And there's a bunch of healthcare exemptions on entity level in the Colorado Privacy Act, but other state laws. So in any respect, so I think that this idea of like, if you're required to provide the opt-out of profiling, then you need to provide information regarding that. But that's a big if, I guess, is the takeaway here. It's not a one-to-one. So the way Colorado eventually handled this, and there's this tug of war, right? There's this tug of war, I think, between civil society advocates who say we want to provide a right to opt out of profiling, upfront right to opt out of profiling, which is functionally what this is, right? I mean, conceptually, I should say, not functionally. So the way they addressed it in Colorado, though, is this concept of actually a right to appeal, right? And I think the reason why this may or may not make sense to you, but I'll suggest to you why this was done, is if you go in and you are applying for a loan, so to speak, right? And then the high risk AI system is used. Are you going to opt out at that point in time? Probably not. You're probably going to say like, well, it is what it is. I'm just going to go through the process. Really, where the concern comes in, I think, is at the back end, right? Which is if you're denied the loan and at that point in time, just customer services, well, what do you want to do? I want to appeal. I want to talk to a customer service agent. I don't think this is accurate, right? And that's functionally what Colorado does, right? Which is this notice of adverse decision, which is, if an adverse decision happens as a result, again, of a high risk processing activity in a consequential decision-making setting, then you need to be provided with this notice. And it's very broad about how the notice will be provided. I think Owen referred to that previously. But it's these three things, right? The degree to which and the manner in which the system contributed to it, the type of data, and have extreme significance, right? It does not say the data that was processed. It says the type of data, right? And the source of the data, right? So this is notice to an individual, but it's also not a notice specific to the individual, right? So one of the ways in which the law intends to be a little bit more business friendly in that regard, right? So anyway, so if in fact you are going through the process of notice of adverse decision, or you get an adverse consequential decision, then this notice would be provided to you, but it's a really summary type of a notice, right? So what are your rights then if this happens? Well, you've got the right to correction. And again, you'll say like, well, doesn't this exist in the Colorado Privacy Act? It does. I'm not suggesting it doesn't. But remember, the scopes of these two laws are fundamentally different, right? Colorado Privacy Act has things like 100,000 consumer threshold. Shelby talked before about the definition of consumer applying to both employees and consumers, ordinary consumers, right? And arguably the law should have used the word individuals instead of consumers to not give that suggestion. But nonetheless, because of the different scopes here, you have the right to correction, right? An opportunity to correct any incorrect personal data that the system processed to make that decision. And I think this is one of these areas where you will see the Attorney General's office flesh this out and probably link this to its rulemaking, the Colorado Privacy Act rulemaking around the right to correction there. And then you have the right to appeal, right? And so I think this, again, conceptually, as I was trying to set it up earlier, is, this would be the adverse decision comes in, and now I would like to talk to a human being, right? But there's not the absolute right to talk to a human being. There's a right to talk to a human being if human review is technically feasible, right? So again, there I think there's this give and take that you see in this law where it's trying to say like, okay, we want to provide certain rights to people that make sense, or I would suggest to you may or may not make sense depending upon your view of this whole thing. But to do it in a way where we're not going to say an absolute human review, it's the technically feasible human review, right? And keep in mind too that Colorado, with the Colorado Privacy Act rules, has gone through in the profiling, has gone through a lot of this discussion about like human review and involvement of human review. So this is some place where you could certainly imagine after the statute settles and the task force goes through, that the Attorney General's office has the opportunity to kind of really flesh this out through rulemaking. Okay. And then we've got, if we, again, continue around that wheel we were talking about before, we've got the public disclosures, right? Again, I want to point out that on the left side there, it says the types of high-risk AI systems the deployer currently deploys. So it says types. It doesn't say specifics here. It says types. And again, I think the words have significance here, right? And what the lawmakers were trying to get after. The risk mitigation, these are general statements about how the deployer manages known or reasonably foreseeable risks. This is not, chapter and verse of every single thing. You can imagine like this playing out in a paragraph or two, maybe more. And then finally, there is this one in detail, right? And you finally see here this link to in detail, the nature, source, and extent of information collected and used by the deployer. But again, these are not specific to the consumer, right? That individual. These are talked about, the types of data that you're using as part of this system. The statement has to be made available on the website. Owen referred to this make available language that I think, it kind of permeates throughout the statute. And this concept of make available is not, it doesn't say things. Or if you looked at earlier drafts of the bill, right, it would say like specifics about where you need to make it available. And I think when I see earlier drafts of the bill too, keeping in mind like SB Connecticut, which was really the, part and parcel of this SB 205 in Colorado. And so, I think that this is one of these areas where the Attorney General's office will come in and provide some flexibility here. And it was intended to be, and the reading of how the red lines were developed is intended to be, flexible in that regard, right? To not specifically require how you would do this. And I also want to emphasize, because this was one of the final changes that was made in the weekend and a couple of days before the law passed. When the law was out in the House, there was modifications to this idea of trade secrets and information that you could withhold, right? There's nothing in this law that says that developers or deployers would need to be putting out their trade secrets. Quite to the opposite, it protects trade secrets. And it protects any other information protected under state or federal law. The concern out of civil society was that the language that preceded that change of state or federal law was very broad, and that it could be used by developers or deployers to maybe withhold information. I don't know, you make your own opinions about that, but that was basically the tug of war there. But what I will say to you is, if you have not taken a look at the Colorado Trade Secrets Act and the definition of trade secrets, I really would encourage you to take a look at that. It is very broad, the definition of trade secrets in the Colorado Trade Secrets Act. And that is, at the end of the day, that is protected by law. There is nothing that this statute could do that would require a developer or a deployer to put that type of information out to the public, right? So there is a structure in place that protects that type of, trade secret information for sure. Okay, I think I belabored the point on that one. Small business exemption. Erica had alluded to this before. So again, let's take a step back. Let's talk about what's the concept here, right? The concept here is that you get small businesses who are basically using these products out of the box, right? They're basically using that product the way that it was intended to use that product. They're not like modifying it to their own needs, right? And as a small business, they're not going to be able to do a lot of the things that, like the impact assessments, et cetera, that Eric talked about before, right? And so the law recognizes this, and what it says is, if you've got 50 full-time equivalent employees, and you're basically, and there's a lot of words on paper here, but to summarize, you're using it out of the box, right? And you're using it out of the box, then you don't have to comply with certain of the requirements, and I've got them listed there: risk management policy and program, impact assessment, and public disclosure requirements. I think, if memory serves, that's like the consumer rights and the consumer notice disclosures would have to be provided as well. But this really is intended to be this opportunity for small businesses to be able to continue to use these. And I'll say what's in the background too, right? Which I think is Owen kind of alluded to this, but I think the expectation is over time is that a lot of this stuff is going to be worked out between developers and deployers and the contracts that are being put in place, right? Because you can say, well, what about these disclosures that should be made and stuff like that? Well, there's nothing that prohibits a developer from coming up with these disclosures and then providing them to the deployer if it's out of the box, right? And there actually was in the red lines, if you track the red lines, in particular, I think this was part of the Connecticut red lines, there was actually a provision in place in which it actually said that the developer and deployer could contract around these. And that was eventually taken out based on floor statements. I think it was taken out based upon the idea that, it should be up to the parties to contract. But I think conceptually, this idea again is, these contracts between developers are really going to be important to get right about making sure that there's adequate risk of loss and documentation, all those types of things. Okay, so the last one, and I think I get turn it over to Shelby for a few slides, is notification of algorithm discrimination. This is, again, something that Owen talked about before. Here it's, again, you're the deployer, right? And you have 90 days to notify the Attorney General of the high-risk AI system is called algorithm discrimination. Now, what I think is important to draw out is that the one Owen showed you before and the one that I'm showing you now, it talks about notifying the Attorney General's office. It never talks about notifying consumers themselves, right? So if you're familiar with data breach notification statutes, the notification obligation is primarily to the consumers, right? And then secondarily to the Attorney General's office or to other regulators, like regulators is a strong word, but divisions of insurance and those types of words, those types of entities, right? So here, though, it's in the Attorney General's office and not to consumers. I think that is a very important distinction to be made. Okay, so let me hand it back over to Shelby to talk about the one section of the law that's a touch broader.
Thanks, Dave. Okay, so AI disclosure obligations. Under this law, a deployer or a developer that makes available a high-risk AI system to consumers, where the consumer can actually interact with that AI system, must provide a disclosure to the consumer that notifies them that, hey, you're interacting with an AI system right now. I really think of this as similar to the chatbot law in California, if any of you are familiar with that law, where basically when a consumer interacts with a bot, they have to be notified that they're interacting with a bot, not a human. So like I said, I think of this kind of in the same way here, but there is a broad exception to this obligation. A disclosure is not going to be required if it would be obvious to a reasonable person that they are interacting with an AI system. So again, with my bot example, you log in to use a bot and it says, hi, I'm a bot. And it's like a little robot dancing or something. You're going to know that you're interacting with a bot, and that's going to be more obvious. So I think of this kind of in the same way here. If, you're interacting with a AI system and it's obvious that it's an AI system, then the deployer and that developer wouldn't be required to provide an additional disclosure. So we just wanted to touch on this broad obligation, and then I'm going to actually pass it back to Dave to cover more exemptions under the law.
Yeah, thanks, Shelby. So we'll power through exemptions, and then we'll get you to enforcement rulemaking and the big finish here. So we're almost there. And with exemptions, right? I mean, this is kind of short. I mean, if I was in a privacy law discussion with you guys, the exemptions tend to go on for like 5 pages, right? But this one's not the case. And there are general exemptions. So I've got 3 slides here: general, federal, and then industry specific, right? So the general exemptions, what you'll see are things like, comply with law, cooperate with law enforcement, right? Those all make sense, of course. What I do want to point out is that 1, 2, 3, fourth one down: prevent, detect, respond to security incidents and fraud, et cetera. And it continues to go on. I just could only put so many words on here and make it fit, except for the use of facial recognition technology, right? This was a concern. I think we saw this in the Connecticut, the report that came out of the Attorney General's office in Connecticut about, facial recognition technology and how that was being used and how that was coming into play with the fraud exemption. This was also something I think that you can see out of like the Rite Aid example with the FTC, right? The use of facial recognition technology. So the concept here was to kind of really hem this fraud exemption, and to exclude facial recognition technology, right? But again, there are this large exemption for fraud, and I think that's something that like a number of providers out there are going to be able to rely upon, who are providing products that are intended to detect and prevent fraud. So, and you see the rest of the list here. I don't need to read it to you. This federal exemption concept, right? So this is really, I mean, if you're coming to this from a privacy law, this is, I think, kind of new to you. The top one, I think the top 2 are the ones I really want to focus on here. If the high-risk AI system has been approved or authorized, certified, et cetera, by a federal agency, then that's going to be exempt, right? And then the second one there, I think, is also important, which is this high risk. It's in compliance with, quote, substantially equivalent standards established by a federal agency. The word substantially equivalent, I think, is really interesting. Word choice here, you see it pop up maybe 2 times in the statute where it talks about exemptions, right? And I think the concept underlying this one that comes through is, the idea is that you would be subject to 1 regulator, not 2 regulators, right? By this, if there is in fact a federal agency that has a substantially equivalent standards. And this is very forward-looking, right? This is obviously an emerging area, and there's been a lot out of the Biden administration on this topic. But as far as, actual documentation, standards, those types of things, we're not quite there yet in a lot of areas. So I think this is forward-looking, where the law says, hey, as these things develop, if they're deemed to be substantially equivalent, there will in fact be exemptions. And again, this goes on. I don't, you can read the exemptions as well as I can, but just to kind of show you how this all kind of fits together. Okay, industry-specific exemptions, right? There is no GLBA exemption in this law. There is no covered entity exemption in this law, right? The way it addresses it is if you're a healthcare organization, there's a limited exemption if you're basically using AI as a tool to provide services. If you're banking, then it's, there's a substantially equivalent regime out there, then you would be exempt, but I'm not familiar with where that would be right now. But again, this is sort of forward looking. I think, the insurers one is for those of you who are in insurance, be aware Colorado has an existing law that we're waiting on rulemaking from the Commissioner of Insurance on that will in fact provide for algorithmic discrimination rulemaking around this very topic, right? And so there, it's recognized that that's going to happen, and so that is exempt. What I will say is I do think this area is one that is ripe for the task force. I think, getting in the weeds on use cases and where you would see specific exemptions in place for use cases is one in which, now that the law is signed, that there should be a lot of focus on beneficial use cases, in particular, I think in the healthcare field, right? Beneficial use cases, to carve those out, I would expect that there would be a lot of thought and effort placed in that area in the task force. Okay, let me turn it over to Eric, and then we got 4 minutes to get it done, Eric, so I'll let you power through.
Sure. Thanks, Dave. All right, folks, when it comes to enforcement, big things to keep in mind. This is an exclusive tool of the Colorado State Attorney General. There is no private right of action. There is no district attorney enforcement of it. And it involves civil penalties, as noted here on the slide, with up to $20,000 per violation. There is the ability for organizations that are accused of violating the act to raise an affirmative defense. Obviously, that means that the organization is going to have the burden of proving that it has met the requirements of that affirmative defense. And those would be that it discovered and cured the violation, and also that it is otherwise in compliance with the NIST Artificial Intelligence Risk Management Framework or another recognized framework that the Colorado Attorney General has recognized. I do want to point out this bottom block here that we have limits for the rebuttable presumption and the affirmative defense. Owen talked about rebuttable presumptions earlier. The concept for this law was to have this be something of a self-contained entity. It was not to create defensive rights that could be invoked against other types of claims or other enforcement actions or private party suits. So when you think about the rebuttable presumption and raising an affirmative defense, those are intended to be in response to enforcement actions brought by the Attorney General. What kind of enforcement action would the Attorney General bring? The last part of the statutory text, you will see that it adds a new element into the Colorado Unfair and Deceptive Trade Practices Act to say that a violation of the Colorado AI Act is an unfair trade practice. So that's going to be the mechanism for an enforcement action. Again, about a year and 8 months, or actually 7 months and 26 days down the road, if not longer. And the reason I kind of remind you of that timeline, when we think about Attorney General rulemaking, the law says that regulations are permissive. The Colorado Attorney General's office has the discretion to decide if and when they want to promulgate regulations. As Dave mentioned, they have on their plate, it looks like, biometric regulations, child privacy regulations, this AI Act, possible regulations. There's another legislative session that will occur in 2025. All of those things are still in the mix to look at how and if and when regulations would come into play. So I would suggest and say, don't forget that the ink on this statute is barely dry. There's a lot more that can happen here on the regulatory front by the state government. We've seen the Securities Exchange Commission start to try to clarify what it really meant when it put out its public traded companies disclosure rules on the cyber front, because it didn't like all of the notices that were coming in. So more to follow. Watch this space. Dave, back to you to wrap it up.
Yeah, thanks, Eric. And we're just about right at time, so let me just kind of power through on, what you should do now. Just give you some ideas, right? As we wait for this 1 year, 8 months, and 15 days to go by, I think the basic stuff that you can talk about internally or AI inventory, like understand current and consider uses, right? Don't wait until the month before to try to understand if and where you are deploying these and whether they're considered to be high risks, right? Start that process now. Contracts. I mean, as I think about how this law is really going to play out, right? I think as you're entering into these contracts now, to be considering, and I should say too, like, let's just be honest, right? Colorado's first, it's not last, right? I mean, it's the first of what is going to be multiple laws in this subject, right? So getting your contracts in order and understanding where the risks are and the risk sharing, I mean, that's stuff that we're already doing with our client base, right? And that's just going to be important. There's no reason to wait for it and to do it now. And a risk management program, I mean, all these things are going to be wrapped up around these laws, I should say, are going to be wrapped around this idea of having maps to framework, responsible deployment, those types of things. I mean, it's in the EUAI Act as well, like responsible deployment aspects. So this is really stuff that I think you can start working on now. Okay, other laws and pending bills, just want to make you familiar. Utah's got one, SB 149, that's out there, disclosures around, general purpose AI. We've got a blog post out on that one. We're working on an article right now about these California bills. There's a number of them right now, and the legislature's not going to close until the end of August. And so we're working on that right now. And subscribe to the blog. Here's our shameless plug portion. But we should be having that out sometime a little bit later this week, that California one. So we'll keep you continually updated on this AI stuff. Thank you for joining us. Really appreciate you guys attending. Hopefully you got a benefit out of it, and we will see you on the next one.